hopefully they can get the message.
The whole point of why clerk existed is there's supposed to be a presumption of regularity in judgments of conviction. There's a great public interest in finality of the judgment, and doing the burden shifting didn't make sense in that sort of scenario. So did Mr. Anderson meet clear and convincing evidence just off of testimony of his client? And I'd say no. There's a reason I submitted these documents and in this order. So I'm going to relate a bit of the procedural history here. Attorney Anderson came to court and submitted the motion and the unsigned affidavit. Part of the reason why I had the transcript of the status conference March 18th is he directly said to the court he was filing that unsigned affidavit and was just filing a signed one later. So it was intended to secure this hearing, that unsigned one. That was submitted by Attorney Anderson on behalf of Ms. Almandinger to meet his burden for the production to get this hearing. So to say it should just be disregarded, shouldn't exist, is nonsense. When we look at that second document, the one that she did sign, I want the court to pay attention to what was added there. We just heard great testimony from here today about she doesn't know the law even though she's an A student from high school. What was added in between the first affidavit and the second? At sub 7, I was not provided nor did I sign a guilty plea question or waiver of rights form. And then they just wrote in that complied with WI procedures. Why would Rebecca Almandinger say that? How does she know what complies with Wisconsin procedures? They've merely just crossed off all the rights that at the time of my waiver of right to counsel and guilt to be mentioned above, I was advised of constitutional rights. They struck all those off, just crossed them off, and then crossed off the right appointed to court by public defender and just wrote as no plea colloquy was done by the judge. What happened in between these affidavits is the state providing that plea questionnaire that she recognized having her name and her signature and her handwriting on it. You'll notice it was handwritten. It even gives her narrative of what happened. I drove a car after drinking alcohol and tested 0.08 or more. It has her signature on it. It has a circle around the sub for waiver of attorney, which does list all of the rights associated with what you have for a criminal case. And this is an incident that happened 20 years ago. She can remember all the specifics that would help her for this hearing, but can't remember any of the specifics that would hurt her. Didn't remember this plea questionnaire, claimed she went to the courts. They said it didn't exist. And then here's a certified copy of it from the courts. That's the purpose of the second transcript of Attorney Anderson telling the courts, hey, Rebecca Almandinger went to Minnesota, asked for the records, told me that they said they had no responsive records. I submitted that because I didn't know if she'd be testifying to that today, and she did. Put that all together, does that mean clear and convincing evidence of a manifest injustice? It does not. It's the self-serving testimony of a defendant. If you accepted Attorney Anderson's argument that what happened today is sufficient to get rid of a past conviction, then what the court's holding is clear and convincing evidence of a manifest injustice is met. Any case, there's not a transcript or a defendant's just willing to say those things. Because the reality is he complains about nothing contradicted and people not showing up to testify. It's his burden. He could have looked for the judge. He could have looked for the clerk. Him shrugging his arms and saying, well, all we have is my client. What a shame. That's his problem because it's his burden. He tries to shove it off onto the state, just as Clark Court said, you can't do that anymore. We're here for Bentley. The burden's on the defendant. And just having a defendant say, I remember some things and not others, isn't enough. Not only that, but her testimony she gave, she did know these rights and she understood them. The reason she entered her guilty plea in court was because she was guilty and she wanted to accept responsibility. I think that one thing we've noticed from sort of comments today in Attorney Anderson's argument and comments at a previous court, Attorney Anderson believes that the classic plea colloquy is something unique in Wisconsin and that other places don't do it, or we shouldn't assume other places do it. And if the plea colloquy didn't happen, then the violation occurs. This, of course, contradicts Wisconsin case law. State v. Serrano, 2017, WI 42, at paragraph 21, that's spelled SURIANO, specifically recognized that the collusive colloquy was never intended to provide any protection greater than what the U.S. Constitution provides. It's the bare minimum. It's what every state does. And furthermore, just showing that a plea, let's say the court believes the defendant that a judge came in, asked how you plead, did no colloquy, which is an extreme claim with no extreme evidence backing up just the self-serving defendant. If the court actually believed that, that still wouldn't be sufficient to meet the burden. State v. Ernst, 2005, WI 107, paragraph 25. Just alleging that a plea colloquy is defective or missing is not enough to meet the collateral attack standard. You also have to show your client didn't understand the rights themselves. Just showing the plea colloquy didn't exist, not enough. And I don't think you've shown that, because Rebecca Almandinger comes off as a pretty intelligent person. She was an A student in high school. She said she knew the rights, but quite frankly was raised too good by her parents, raised to accept responsibility for her actions. I think based on that, the court cannot find that the defendant has met their burden. Thank you.
Do you have any rebuttal? You don't need to.
The record is what the record is, Judge.
All right, thank you. I am taking this under advisement because obviously I've not been able to review the exhibits except for the ones that have been already filed in the case. So I'll get a written decision out promptly. Anything further other than that? Well, we do need to set another date. Mr. Anderson, would you like your September 22nd date?
Sure. Let's call it Bruce Anderson Day. Let's fill it up.
How about we fill it in? We just double book it with the 9:30.
Okay.
So 9:30, September 22nd. We will see you then.
Oh, what time did you say?
9:30.
And that's just the oral ruling, right?
I'm gonna do a written decision, but it'll be a status after that decision.
Okay, because I won't be there for that day.
Well, you'll get the written a lot sooner than that day.
Perfect.
Zoom info? She'll have a notice.
What? Zoom? Zoom? Yeah, Zoom is fine. You may appear by Zoom as well. Your attorney will most likely be appearing by Zoom on that date. So I'm okay if you appear by Zoom. It's actually easier for the court.
Okay.
But you may come in person. That's your right. Okay. All right. Thank you. You can come get your notice and you're free to leave.
All right, let's talk about that. We wrapped up this motion hearing with a closing sequence that pulled no punches. DA Kevin Schmidt came out swinging with a laser-focused argument that zeroed in on the legal standards and the credibility or lack thereof of the defendant's testimony. And look, say what you want about style, but the man knows how to stack a case. His main theme, the burden of proof, sits squarely on the defense, and in his words, Attorney Anderson and Ms. Almandinger simply didn't carry it. Schmidt pointed to the 2022 shift in Wisconsin law State versus Clark, which slammed the door on the old blame the state strategy when there's no transcript. Now it's Bentley all the way. Defendant's burden, clear and convincing evidence required. Period. One of Schmidt's sharpest moments came when he deconstructed the affidavits. He reminded the court that it was Anderson himself who filed the unsigned affidavit just to get the hearing scheduled, so to turn around and dismiss it as irrelevant? Nonsense, Schmidt said. That's a fair hit. He also questioned why, in the edited signed affidavit, Almandinger suddenly knew to claim the procedures weren't in compliance with Wisconsin standards. His point, how would she know that? She's not a lawyer. He argued that the changes were clearly coached and that her narrative conveniently shifted only after the state produced a certified plea questionnaire, one she initially claimed didn't exist. That document, by the way, showed her own handwriting acknowledging the facts of the case and waiving her right to counsel. Not a great look for the defense. But Schmidt didn't stop there. He invoked State v. earnest to argue that even if there wasn't a textbook plea colloquy, that alone isn't enough to invalidate a conviction. You also have to show that the defendant didn't understand their rights, and he wasn't buying that. He emphasized Almstedinger's education, her own statements that she believed she was guilty, and perhaps most poignantly, her good upbringing, as a reason she chose to take responsibility rather than argue. He closed with a pretty powerful takeaway. The defense's case boiled down to a defendant who remembered everything helpful, forgot everything harmful, and had every incentive to change the past now that she's facing felony charges. Judge Mogen, meanwhile, stayed composed and grounded as ever. She reminded both parties that she'd take the matter under advisement and issue a written decision. You could tell she wanted time to weigh the exhibits, including those filed mid-hearing. There was a little levity at the end, setting the next hearing for Bruce Anderson Day, which got a few laughs and kept things human. It was a nice break from the legal chess match we'd just watched, so what we saw was a clean finish to a very nuanced hearing. No shouting, no tricks, just a clash of interpretations about justice, responsibility, and the fairness of a plea made 2 decades ago. Did the system fail a young, uninformed defendant? Or is this just a retroactive Hail Mary to escape today's consequences? That's for Judge Mogen to decide. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.